Hello, my name is Grigory Lutsenko. I'm the head of AML Department at COREDO. Today, we will look at Anti-Money Laundering Officer, Money Laundering Reporting Officer, and Money Laundering Compliance Officer. Subscribe to our channel and hit a bell not to miss new videos. You may encounter these terms frequently in different situations, such as when filling out a bank questionnaire or studying AML-related materials. For example, when filling out a questionnaire at the bank, you will be asked who in your company is the AML Officer, MLRO, or MLCO. In this case, you need to clearly understand who is meant, so that you do not give the bank false information. So, who are they and what are differences between these roles? Let's start with the AML Officer. This concept dates back to the late 20th century, and it is difficult to determine who's created and started using it. The concept of the AML Officer emerged in response to the requirements of FATF and local laws to appoint responsible person to combat money laundering. Therefore, the concept of AML Officer emerged in the context of implementing these requirements rather than being introduced by a specific person or organization. The AML Officer has gradually been developed into the more specialized roles of MLRO and MLCO. Today, this concept is rarely used in the context of a responsible person in a company, MLCO. This concept is formed both informally and stated in legal requirements. This person is responsible for ensuring compliance with all regulations and requirements related to AML legislation. This includes development of internal policies, internal controls, risk analysis, compliance with statutory regulation, and other obligations established by law. We have discussed this topic in our video dedicated to the concept of compliance. I recommend you to watch it. The link will be in the description. The exact list of duties is established by local law, as is the position title. For example, in the Czech Republic, such a position is called pověřená osoba and is regulated by paragraph 22a. Now we will look at the requirements and duties of an MLCO in the Czech Republic. The requirement for MLCO in Czech Republic is 1. It must be a member of the statutory body of the obligated person. If the obligated person is entrepreneur, he is an MLCO. The Czech law does not stipulate any other requirements. However, they are determined by the AML directive, and MLCO must have sufficient knowledge, skills, and experience to assess and manage AML risks, understand the obligated person's business model and the sector it operates in, be informed of decisions that may affect AML risks. The MLCO's duties are to fulfill all obligations of the AML Act. The main duties are creating the organization's internal policies, creation of the organization risk assessment, appointing an MLRO, training of employees, the obligation to transmit information requested by the FAO, identifying suspicious activity and notifying the FAO of suspicious activity, conducting customer identification and due diligence, information recording, and other duties depending on type of obligated person. If the MLCO delegates any of his duties, he is still responsible for them. The organization needs to establish a management system that ensures that all the requirements of the AML Acts are met. MLRO. This is a concept formed both informally and stated in legal requirements. This is the person responsible for filing suspicious activity reports. The MLRO also ensures contact with the regulator. This position has more specific function and is specialized on reporting issues. The exact list of duties is established by local law as the position title. In the Czech Republic, MLRO is called kontaktní osoba, and it is regulated by 22nd paragraph of the Czech AML Act. If we refer to it, we can see that the obligated person must appoint a responsible employee or board member to the position of MLRO. The MLRO has two basic duties: duty to report suspicious activity under paragraph 18 of AML law and the duty to ensure ongoing contact with the FAO. And let's start with ongoing contact with the FAO. First thing, when appointing a contact person, there is an obligation to provide the MLRO's contacts a phone number and electronic contact, which means an email. When the FAO contacts this means of communication, the MLRO must interact with them. Second, speaking the Czech language. While the law doesn't specify it, Czech is the official language of the Czech Republic. Therefore, the MLRO should speak Czech to comply with the duty of ongoing contact with the FAO. Let's look at the duties under the 18th paragraph of the AML Act, notification of suspicious activity. Evaluate available information and identify suspicious activity. If suspicious activity is detected, the FAO must be notified. This is the first point of the 18th paragraph of AML law. Next, to prepare suspicious activity notification in appropriate manner. These are points 2, 3, 5, 7, and 8 of the 18th paragraph of AML law, and notify the FAO of the appointment of an MLRO. This is point 6 of the 18th paragraph of AML law. Paragraph 18 describes the obligated person's requirements, but not the MLRO. Thus, the minimum duties of the MLRO are to file the SAR and ensure ongoing contact with the FAO. The rest of the MLRO's responsibilities can be set out in internal company regulations based on the processes developing. Notifying the FAO of the appointment MLRO. According to a change in the law of 30 December 2024, all obligated persons must notify the FAO of appointment of the MLRO, except lawyers and notaries. Previously, this applied only to credit and financial institutions, gambling organizations, obligated person under paragraph 2.1h in crypto companies. Now, this requirement also applied to the following persons: real estate agent and property developers, auditors, distributors, art dealers, pawnbrokers, fund trustees, bankruptcy trustees, dealers in precious metal or stones, and other persons under the AML Act. For all obligated persons, including those listed above, the notice period is from the 1st of February 2025 to the 3rd of March 2025. This rule accepts lawyers and notaries. If you become an obligated person later than this period, the law requires you to notify the FAO of your MLRO designation within 30 days of becoming an obligated person. If you previously notified the FAO of the MLRO designation, you must enforce the FAO again in a new format. The following MLRO details must be included in the FAO notification: first and last name, position, contact phone and number and email, hours of works, type of obligated person. If there is a change in these details, the FAO must be notified within 15 days of this changed date. The online form on the regulator's website is used to prepare the notification, which, according to the regulator's statement, shall be ready soon. To send notification, you need the government email. In Czech, it is datova schranka. If you do not have access to it, you should restore access as soon as possible. If you are an obligated person and entrepreneur, you do not employ anybody, you must to declare yourself at MLRO. Requirements for MLRO. Earlier, we discussed that an MLRO should speak Czech. The law also sets out the following requirements for MLRO. In credit and financial institution, a member of the statutory body cannot be an MLRO unless justified by the scale and nature of the obligated person's business. Let's simplify. Do not set a director on the MLRO position. In credit and financial institution, an employee responsible for entering or conducting deals or a person involved in an internal audit cannot be an MLRO unless justified by the scope and nature of the obligated person's activities. Let's simplify. An independent person must hold the position of MLRO for all obligated persons. If the MLRO is not a member of the statutory body, there should be direct contact with a member of the obligated person's statutory body or oversight body. Let's simplify. The MLRO should directly contact the company's directors. Responsibility of the obligated person for violation of paragraph 22.2 of the AML Act, the duty to notify the FAO of the appointment of an MLRO, the obligated person is liable to a fine of up to 1 million crown. For violation of paragraph 18 of the AML Act, duty to identify suspicious activity and notify suspicious activity, and duty to ensure ongoing contact with the FAO, the obligated person is liable to a fine of up to 5 million crowns or a high fine in more serious situation. Personal responsibility. Failure to fulfill duties results in a violation of paragraphs 18 and 22 of AML Act by the obligated person. The individual is liable to a fine up to 1 million crowns. Today we looked at the key roles in the company related to anti-money laundering. If you still have questions or want to learn more, feel free to leave a comment and subscribe to our channel. Thanks for being with us.